Back to Ring of Fire, I'm Mike Papantonio. Republicans have already managed to protect their corporate backers by packing our court system with judicial hacks. But that's not good enough for groups like the Chamber of Commerce. So they've come up with a new scheme to protect businesses from lawsuits. I have author Jim Hightower with me now to talk about those schemes. Jim, so right now you have corporate America. They deregulated everything. They refuse to do any kind of self-policing. They have stacked the courts to the brim. You can't stack them anymore. They're controlling Congress. They're controlling the White House for all practical purposes. They obviously control corporate media. So, but that's still not enough for them. They still want to take some. They want to take some rights away still. What is this arbitration scheme that they have in mind?
Well, this is your Seventh Amendment right to take a corporate wrongdoer to court. If you get fired unfairly, you get sexually harassed, you've been cheated on a purchase, etc., you have a right to take that wrongdoer to court and find justice. However, what's happened is over the last some odd years, very odd years actually, the Supreme Court, all the way up to that level, has okayed a private justice system run by for corporations. So instead of being able to go to court, you are forced into what's called binding mandatory arbitration, a compulsory system that is dominated by the corporations themselves that renders so-called justice at your expense.
Basically what happens here, Jim, is when you buy anything nowadays, this is where it's headed. You buy an insurance policy, you buy a telephone, you buy virtually any kind of service at all, they're going to have an arbitration clause in there. And the reason they want the arbitration clause in there is because the Chamber of Commerce has proven, and they're all behind this. Chamber of Commerce, this has been their big pet project. They know that 97% of the time the corporation will win where it comes to an issue that's being arbitrated. Consumer loses, corporation wins. Did I get that right?
Well, and one reason corporations win the overwhelming number of cases, as you say, 95 to 100%, depending on which arbitration outfit you're looking at, is because the deck is stacked. First of all, this is not a public judicial process. This is a private process, meaning the same rules of fairness don't necessarily apply in arbitration as they do in court cases. Also, here's an interesting little tidbit: the corporation gets to choose the judge.
Yeah,
no, well, that's pretty handy. And they choose, Pat, the judges that have a record of having sided with the corporation. They also get to choose the venue, so they can make you travel clear across country if they want to, making it inconvenient and so expensive that you can't do it.
One thing they do that we've found, we see it day to day, is we'll find arbitrators, Jim, that actually have somehow worked for the industry for their entire career, or they're promised the right to work for them after they work as an arbitrator. They're shameless about it. There's never an issue of, is there a conflict? Conflict is old news here. And the other thing is that's so interesting to me, Jim, is there's no appeal. Whatever that paid little character that works for corporate America, whatever that paid little character says, the consumer has to live with. I mean, how does it get any better for corporate America?
Well, you don't have to be in who's who to know what's what.
Yeah.
This system is designed by the corporations in conjunction with Supreme Court justices like the gang of 5 thugs on the court that stole our elections from the people and turned it over to the corporate money interests. The same 5 have been the ones ruling for the corporations in mandating these arbitration agreements. And as you indicate, not only do they take care of those arbitrators, you can make as much as $10,000 a case arbitrating. You can make $1 million a year Now, if you're a judge on a state court, for example, you might be making 150, 175, maybe as much as $200,000 a year. But here comes this arbitration firm waving the possibility of $10,000 a day at you. So they pick these judicial stars off of the courts and turn them into arbitrators. So they're destroying what ethical balance that there might be on courts with money.
The goal of the U.S. Chamber of Commerce, of course, is to do away with jury trials across the board. They don't want juries judging their conduct. When they kill a person with a bad product, and they do it simply so they can increase profits, when they make a decision to steal mom and pop's pension programs, isn't it a great world where you don't have anybody judging you except your friends? I mean, how does it get any better than that? But this has an historical basis. In 1925, you had Congress that said, we're gonna have this arbitration, this Federal Arbitration Act of, I think it was 1925, and we're gonna put it in place. And since then, the U.S. Supreme Court has been winding it to the point to where the consumer has no chance at all in an arbitration setting.
Well, even to the extreme that the court basically has outlawed class actions in these arbitration hearings. Class action, as you know, but simply means that instead of when you've been wrong by maybe a couple of $100 or $1,000, you're not going to be able to go to court with that or go into arbitration with that, because it's going to cost you more than that damage to be able to present your case. But if you join together with other consumers or job seekers who've been similarly disadvantaged, then you can, instead of having one case or 100 different cases, you can compile those 100 cases into one. And that saves taxpayers money. It saves across the board. But the courts, the Supreme Court, has basically ruled that no, we were not even going to allow you to have your class action rights.
Well, no surprise here, Jim. This was really launched in the Solid South. It started, you had a huge amount of energy behind this in Texas, of course, your home, Alabama, Mississippi, Georgia. That's where industry came first. They started in those states, and they would start off by saying, gee, if you buy this phone service and we do something horrible to you, you can't sue us. You have to appear in front of an arbitration panel, and you have to follow this arbitration clause. But what they did is they buried the clause. If you read a contract, look, I've been practicing law for 30 years. Sometimes it's impossible for me to understand what in the hell they're talking about in that arbitration clause that everybody signs.
Well, again, these clauses are written by corporate lawyers for the corporate interests. So it is in their interest to make it, to put it in the fine print. And if you look into the dictionary about under the fine print word there, you will find that it means deliberately obscure. We're trying to hide it from you. And that's why it's put in there, and in indecipherable hieroglyphics, as you indicate. It's unreadable, even if you might think that you should read it, because you're not told by whoever's selling you that television set that, by the way, Bob, you might just want to read this clause in subparagraph 97, section 8 here, because it says. They don't do that. They don't indicate at all that you're being subjected to a privatized judicial system and having your constitutional right to a fair trial taken away from you.
You know, the sick side of this, and I guess you call it poetic justice to some degree. Some people get caught up in this. A lot of people, you know, in the southern states especially, where this really started originating in true form, is you had organizations that were tort reform organizations. They were there, supposedly they're going to make the tort system better. Well, yeah, they were there to make it better for corporate America. But the interesting thing is, and as I see these people, sometimes they'll come to, you'll hear stories where they go to a lawyer's office and they'll say to the lawyer, well, you know, I've been gouged by this bank. This bank has cost me $10,000. And now they're telling me I have to sit in front of a panel of people that are actually employed by the bank to decide if that bank actually did anything wrong. And the irony to this whole thing is that person who's now complaining about having to be a victim of arbitration was ready, willing, and able to do this. I mean, they were all in where it came to saying, yes, I'm going to do this because Chamber of Commerce told me that it was going to save me money in the long run. We're going to stop these bad lawyers for doing the bad things they do, and it's going to be better for everybody. You remember that pitch, Jim?
Absolutely, and they continue to do that, continue to try to nibble away at the people's right to the courthouse door. And you know, you indicate that this has happened in the southern states, and there's a reason for that, which is that corporations kept losing in state courts in the South because the people of the South are not really enamored of big corporations running roughshod over small farmers and small business people and consumers and their air and water and et cetera. So court cases down here, trial by jury, the juries tend to decide with the people who get hurt rather than the corporation doing the hurting. So that's why they moved quickly down here, because we were able to link up with good lawyers to find some justice.
Well, it's that reptile mind, isn't it, Jim? It's the old reptilian mind that, you know, you get the juror on there that never believes it's going to be their child who's horribly injured. Get the juror on there who believes that they're somehow above bad things happening to them. Get the juror on there who's so selfish that he would actually rule against his neighbor so he could save $2. That is what happened in the South. I remember watching this tort reform scheme taking place down here, and arbitration was really the big sale, wasn't it? Arbitration was what corporate America wanted in the end. Well, Jim, let me ask you something. Isn't the argument that we're hearing from the Supreme Court saying, okay, well, gee, if they don't want to sign the arbitration clause, that's fine. They can just go next door and buy a product from somebody else in about a minute. How about telling me how insane it is for the U.S. Supreme Court to say, gee, if they don't want to buy that phone, they can buy another phone. Everything's going to be just fine.
It's just how completely clueless our Supreme Court justices have become, especially the 5 that are serving corporate interest on that court. Because you know, maybe 20 years, 30 years ago, that might have been possible. But now these arbitration clauses are industry-wide. Good luck at finding any department store, finding any chain store that is selling a product without an arbitration clause attached to it. And by the way, an arbitration clause that bans you from having class actions against the corporation. So they have so stacked the deck, and for the jurists to claim to be jurists, trying to be seekers of justice, is an outrage in these cases, because they know that the deck is stacked against the small person.
Jim Hightower, thank you for joining me as usual. This is one of those stories that for some reason mainstream media doesn't want to talk about, because they are really corporate media. They want arbitration, I can promise you that. Thanks for joining me, Jim, okay?
Thank you, Pat.
Jim Hightower is the author of Hightower Lowdown.